affects his area particularly, so we're going to ask him to explain it for us.
Thank you, Mr. Chairman. 2224 is a fairly simple bill. It just authorizes the use of electronic signatures for search warrants. We did this same bill last year. We passed it out of the Senate. It died over in the House Judiciary committee. So currently we can already do electronic arrest warrants. This is to allow for the use for the search warrants. I'll be happy to answer any questions.
All right, you've heard the explanation of the bill. Any questions for Senator Blackwell? Senator Simmons?
Thank you, Mr. Chairman. Isn't this bill already law? Did we pass this before, Mr. Chairman?
We passed it. I think the House killed it.
And from my understanding, it just allows electronic arrest warrants.
Yes, sir.
And I think when we took it up before, one question was, how would that be maintained, or how do we make sure that the actual judge is the one actually authorizing the actual warrant?
I remember that conversation, yes.
Yeah. And so is that still a concern, or?
I'll defer to Senator Blackwell.
Yeah.
I don't know that it's a concern, any more of a concern than someone doing electronic signature for an arrest warrant, which I would think was elevated action.
Okay. And is it, I guess, one other question, Mr. Chairman?
Sure.
Would there be any cost associated with trying to maintain a system that would maintain electronic signatures for arrest warrants?
Not that I'm aware of.
Okay.
I mean, they already do it for the arrest warrants, and they're just adding the search warrants now.
Okay. Thank you, Mr. Chairman. Thank you, Senator, for you.
Absolutely, yeah. All right, other questions? If not, then a motion. Motion is titled sufficiently passed. All in favor say aye. Any opposed, nay. The ayes have it. Thank you, Senator Blackwell. Appreciate it. I think Senator McCon is going to be doing our second bill, and he is doing forestry for the moment, so he'll be back with us in just a second. We're going to go on down to, I think, Senate Bill 2. Let's see, is Senator Barnett with us? There he is. Senate Bill 2264. Do you have that one, Senator Barnett? All right, we'll recognize you to explain that one.
Thank you, Mr. Chairman.
This was a committee substitute, I believe.
Yes, sir. Thank you.
Yeah.
This was a bill that we passed out of the Senate last year and got hijacked, I guess, in the House. But basically what this bill does, it was a recommendation by peer 2020 that was established under Senate Bill 2212. And it established an advisory committee, and that advisory committee included the president of the Sheriff's Association, a representative of the Prosecutors Association, a circuit court judge appointed by the Chief Justice Randolph, and the deputy commissioner of the Department of Corrections. All of the people that was on this advisory committee. And what it basically said is that there should be some uniform way of reporting jail census data across the board to everybody. And again, this measure does not cost the state of Mississippi any money, because ITS already has, and they stated before that they already have everything in place to be able to make sure that this happens. And a few of the things that this bill will do is that from the law enforcement, it would also help them with the service of warrants, locating suspects, witnesses, confirming trial dates. For the prosecutors, it will help them in the same thing in locating witnesses, identifying cases of prolonged and pretrial detention. From the Department of Corrections, how it helps them is that basically it helps them in the same way as to locating those people who are on probation or parole who have failed to report. And you know, we have had instances where these people fail to report and then they go out and do other things, but this bill brings all that home. It also does not require, like I said before, any sheriff department to spend any additional monies in making sure that this, and like I said before, ITS has the software and everything in place to make sure that this does happen. So basically, when you see places that have these big case logs and people are sitting in jail for ever, we don't have a court date or a bond date, this right here helps simplify. It lets everybody know where everybody is at all times. It is just a uniform reporting mechanism for sheriff departments, Department of Corrections. It gets everybody that involved in that aspect of it. So, Mr. Chairman, I'm open to any questions if there may be any.
All right, that was a good explanation. Are there questions? Senator Super.
Thank you, Mr. Chairman. Senator Barnett, is the Sheriff's Association good with this?
The Sheriff's Association is good with this. That's why we have the committee sub. Sorry.
All right, I appreciate it.
Yes, sir.
Good question. Any other questions? Senator Simmons.
Thank you, Mr. Chairman. I think this is a great deal. I just remember last year, there was a concern on when we have juveniles in custody, what if any redaction or what if any information would not be disclosed regarding juveniles that are detained in jails. And I'm looking here to see.
Lines 115 through 117, I think addresses your specific question. Perhaps Senator Simmons, if you'll look at that and see if that answers it.
What line, Mr. Chairman?
115 through 117 of the committee sub.
Oh, the committee sub.
Yep.
Thank you.
Okay. Other questions? If not, Senator Barnett for a motion.
Yes, sir. Titles and Fisher do pass committee sub.
Heard the motion, all in favor say aye. Aye. Any opposed, nay. The ayes have it. Thank you for presenting that. Appreciate it.
Thank you.
All right, we're going to jump down to Senate Bill 2235. This one is dealing with the elements of making a terroristic threat. This is our Friends of the Prosecutors Association have asked for this particular bill, and it's a very short bill. If you look on line 16, it's got 3 little dots, and on line 20, it's 3 little dots. And what those dots leave out is currently, is my understanding, and I think we have some folks from the Prosecutors Association if we need to ask them. But currently, if you go and say that you're going to blow up a building, the current law, those little dots, which would be missing, says basically you're making a demand. So I'm going to call and say I'm going to blow up your building if you don't give me $10,000 or whatever. Most bomb threats and those types of things, you know, high schools or other things like that, they don't ask for something. They just want to cause chaos and, you know, get off the day from school or whatever. So they just say, I'm going to blow your building up, and they don't make a threat or demand as far as payment or whatever. So what this bill would do and change is that it would remove the requirement to make some sort of physical demand in addition to the threat. So that's what it does. It's pretty simple. If I didn't cover that, our DA's friends can, I think Mr. Clay represents them. Would you like to speak to that? All right, any questions? Not? Yes.
Quick question. Yeah. Does the threat have to be communicated directly to someone? I mean, not just off the cuff comment.
No, I think it defines, it's current law defines the actual terrorism. It's just, y'all would, if you pass this, you'd be deleting the C to the
Yeah, the current definition is basically a person commits the offense of making a terroristic threat when the person makes a threat to commit a crime of violence or a threat to cause bodily injury to another person if the threat does in fact cause a reasonable expectation or reasonable fear of the imminent commission of an offense, and if in making the threat the person has the intent to intimidate or coerce a civilian population or segment of the civilian population. So it's okay. Senator Thompson. Yeah.
Between items 2A, 1, and 2, should there be a and or? What line? Right here. Look at the end of line 16. 4.
I would say, you don't put anything in the work
you like to offer an or? Now at the proper time, let's just do it. Senator Thompson.
Line 60, that or
All right, you've heard the amendment. Any questions on the amendment? If not, all in favor of the amendment, say aye. Any opposed, nay. The ayes have it. All right, did I see any other questions? I don't want to leave anybody out. All right, titles, Senator Hickman.
Yeah, just quickly. So basically what we're doing is deleting the language that's not there, what the three S's are.
Yes, sir.
Okay, just wanted to make sure.
Yes, sir. Absolutely. Good question. All right. Motion is title sufficient to pass committee sub. All in favor say aye. Any opposed, nay. The ayes have it. All right. And the next one, right behind it, 2245. The change on this one, you will find over on lines 26 through like 27. I think the current language is 21, as opposed to the change would be 18. What I understand the reason for this bill is, I think maybe at USM or some of our college campuses, there have been instances where, as shocking as it may be, someone used a drone to peer into someone's dormitory room or sorority house to view people in, the process of changing clothing or whatnot. And when the university police tried to go after said perpetrator, they were 18, they were not 21. So the DAs, I believe, are asking for this change so that if that incident happens again, that there will be a way of prosecuting said person. Is that correct, Mr. Clay?
Yes, that's correct. Stephen Clay, Prosecutor Association, and this is also a bill that the Senate did pass last year, 29-0.
Thank you. All right, questions?
What's currently happening? Oh, Mr. Chair, sorry.
Yeah.
What's currently happening to someone who is, say, between the ages of 18 and 21?
Apparently nothing. And we got some people very upset about that. As you can imagine, some parents and others that would not like their children's pictures being posted and things of that nature around and about. Other questions? All right, Senator Simmons.
Thank you, Mr. Chairman. So it passed the Senate last year, 49-0, and so it died in the House?
It's out in the House.
Thank you, Mr. Chairman.
You're very welcome. All right, any other questions? Yeah.
If you go down to line 33, change in 21 to 18, shouldn't that be changed as well? Is that right? Occupies violent child 16. Okay. Everybody, I would draw that question,
Yeah.
Mr. Chairman. I see what that is. That's
Okay.
just saying someone's over 21 doing it.
Right. You're right. Exactly. And so they're already covered, but there's a little donut hole, as they call it, gap there from like 18 to 21. It's not being covered. We want to cover it. All right. The motion is tossed to pass. All in favor say aye. Any opposed, nay. The ayes have it. All right, so we're going to bump back up. I think Senator McCon is with us, and he is in high demand this afternoon. So we're going to go to 2227 and recognize him on this particular bill.
Thank you, Mr. Chairman.
Thank you.
I'm going to find that bill.
Second one of that.
All right, Mr. Chairman, this bill is cleanup language, and this is trying to make justice court and municipal courts have the same authority as far as exercising of certain sentences, mostly your disposition alternatives. They're going to send you to non-adjudication status or something like that. Unfortunately, the code is not in existence to allow justice court judges to do that. So what this is, it's a cleanup bill. Really and truly, if you look at B 87 conditions which circuit, county justice, or municipal may impose under section 1 of this section, also include the successful completion of effective evidence-based program. It's really given the authority to make the decision between, like I said, justice, municipal courts, or disposition alternatives. So the intent of the bill, we actually put that language in, correct. So I would entertain questions on that.
Senator Hill?
Which code sections are being removed where the little asterisks are, like which crimes are being removed?
Good question. We'll get.
So I'll get our, I'll have it.
right now, they can't suspend a fine under those crimes, but once you remove it, they will be able to. So I want to see which ones are being
I
taken out.
understand. So let me get that code section pulled for you, and I can get you that language, okay?
It was, the implied consent law is what got removed. It used to say 49,781, comma, 49, so that calculations for the New York comma. Then they added and then they deleted and that was implied.
So the reason was your implied consent law actually had your disposition alternative, being your interlock device and your non-adjudications in a totally different statute or the code.
So that's the only one that it's removing?
That's
Okay, what
per,
else?
per the attorney there, that's the language.
I'm looking at.
Okay.
All right. Other questions?
I'd have a motion, not sufficient to advance these, Mr. Chairman.
All right.
Are there any more questions?
If there are no other questions, you've heard the motion. All in favor say aye.
Aye.
Any opposed, nay?
No,
Okay, the ayes have it. Thank you. And we're gonna go to Senate Bill 2237 now, next. And we're gonna ask and recognize our friends from the Attorney General's office, who I believe are here with us. Yes, Mr. Austin. All right, we'll recognize you to explain 2237 and why the Attorney General's office feels that it's necessary.
Thank you, Mr. Chairman. Thank you, Mr. Committee. Gregory Austin with the Attorney General's office. This bill comes from our cybercrime division. They are currently experiencing some problems between a couple different statutes. Section 97535 is a punishment statute for crime of child exploitation. That crime is a minimum of 5 years and a max of 40 years. This bill that you have in front of you, the statute that is referenced in the bill, 47733, is a probation and parole statute. Our cybercrime division has, in numerous cases, been before judges where defendants have pled guilty to the crime of child exploitation, and those people who have pled guilty have been let off with a suspended sentence and given probation, no jail time, because there is a provision in 47733 that allows that when a death sentence or life imprisonment is the maximum. And so obviously that is not the maximum for the crime of child exploitation. So we're simply including a provision to exclude the crime of child exploitation from that provision that would allow a probation sentence or to allow the judge to get probation for the crime of child exploitation. That's an explanation of the bill. I'm happy to answer any questions.
All right, questions? Senator Simmons.
Yes, thank you, Mr. Chairman. So you are effectively doing it by adding a line, adding the language at line 16?
Yes.
Yes, that is the only change.
And again, by adding that language, what changes in the current law regarding the 5 to 40 year versus what is happening as far as what you are saying some judges have actually done in the application of the law?
We're not changing anything but minimum 5 year and max 30 year for the sentence for the crime of child exploitation. And also just to recognize, we have typically furnished and with lots for our office here, typically we're directing our cybercrime division, so.
And I guess this is a question for
Yeah,
you
you're recognized.
or for the Title 47 is what?
That's a probation and parole statute.
Okay. And so the criminal code is 97, correct?
Yes.
So is 97.533 the crime?
It is.
Okay. And so
97.535 in our reference is the punishment statute for 97.533. 97.535 requires a minimum 5 year, maximum 1 year child exploitation.
This right here. Yeah.
Well,
All
Mr. Chair,
right, Senator Hickman.
while we're doing that, just one quick question. So I try to follow along. So basically what we're doing is we're trying to eliminate a judge being able to just give probation on a child exploitation case, or are we allowing them to do that?
You were prohibiting them from doing that.
Prohibiting them from doing that.
Yes.
Just probation, they have to give some time for a child exploitation case.
That is correct.
Okay.
Sure, go for it. You got to speak up. We can't hear you.
Sorry, Kimberly Purdy, I'm the director of cyber
You recognize?
What we are experiencing, statute 9535 specifically states that the defendant shall be in prison for 5, not less than 5 years. I interpret that to mean shall be in prison. But some attorneys have successfully argued that based on the 47
That was
that authorizes the judge to suspend any sentence that's not, say, death sentence or life imprisonment. Since this is only supposed to be 4 years, some judges have accepted that argument and sentence term defendants to less than 5 years, sometimes 3 years probation, sometimes 5 years.
So you're saying there's a conflict in the laws that is confusing, that some folks are using as an opportunity to get out of having it sentenced for the crime of child exploitation.
Correct. And I would also add that defendants are not eligible for house arrest under this crime, so they're not eligible for house arrest, and as part of that, they should be allowed to
Okay. Senator Simmons, you recognize?
Thank you, Mr. Chairman. And I'm certainly not against what is trying to be achieved. To me, it seems as if you are trying to limit what the penalty should be or what the options at sentencing should be, then you need to specifically write that in Title 97 where you actually have the crime. So if the penalty is 5 to 40 and the issue is you should not be eligible for any probation or parole, then you should write something in Title 97, 5, 35. Like
Well, the drafting attorney disagrees, but
she disagrees.
she disagrees with that, but that's okay.
Okay, I mean,
That's okay. We can do it in both places if you if you'd like to.
so we're gonna leave what's in 97 in 97, but then we're just gonna actually amend the parole.
Because the parole statute is the one they're using to say, well, since child exploitation is not specifically in this parole statute as a suspended sentence option, it must mean the legislature would intend for that to be the case. Senator Hickman.
Thank you, Mr. Chair. I haven't looked at the actual statute, but the statute already has a minimum in it, but they're using this statute to then go back and say
Yes.
that we can now suspend that and go whatever.
Correct.
One more question if I can. So what we basically do by adding this to this section is we don't allow a judge to have any discretion at sentencing, even if someone pleads guilty or there's no negotiation. You have to get back to that 5-year minimum. Is that
Well,
what
you
we're
have
doing?
a discretion between 5 and 40,
But
just not under 5.
So we take away some discretion, just not all discretion.
Well, I think what the Attorney General's office is arguing is that there shouldn't be any discretion, and the statute says 5 to 40, but then you go to a second statute and you're saying, well, maybe there's some gray area there, so let's give a suspended sentence under the 5. And they're trying to clear that up. Is the intent of the bill. Now, whether you want to do that or not is your decision, obviously, but that's, I think, what they're trying to accomplish. Senator Simmons?
I have a motion at the appropriate time, Mr. Chair.
Okay. State your motion. Go ahead.
I move that we lay it on the table, subject to call of the chair.
Would you like to speak to that motion?
Yes. I would like just a little time, and I know Tuesday is the deadline, to just look at 97 and look at also Title 47 to see exactly what's in it, and then also try to get some more information from the Attorney General's office. I'd like to see the sentencing order, if possible, where the judge may have done this and the basis, speak to the DA in that area, if I have time to do that. See what was going on in that case with, I mean, did the DA agree to it and why, what the circumstances? I mean, I just like a little more information. And I'll be willing to work really, really hard over the next day to do that.
Sure. I have no problem with that. If the committee obviously heard the motion to lay the bill on the table, subject to call the chair. All in favor of that motion, say aye. Aye. Any opposed, nay. The ayes have it. All right, you got your time. All right, thank you for that first one. Let's go on down to 2265. Also, bill from our friend of the Attorney General's office. And Mr. Austin, would you like to tee that one up for us?
Yes, sir.
Go for it.
Thank you, Chair. There are three amendments in this bill to specific compensation act for Bureau of Visual Assistance and a legal administrator. 99 first change here. Department of Services, Child Protection Services, child sex abuse crimes are the CPS, a number of years ago, the CPS came out from under DHS, and they were eventually removed from DHS, now they're removed from CPS, and we're just beating that up. The second amendment we are making, we are removing a 25-year age limit for child sexual abuse claims to be made under this Compensation Act. Currently, the statute provides that for compensation under this act, for child sexual abuse claims, they have to be made from victims who have been engaged in their birthday. We're removing that provision. We have seen situations where somebody was sexually abused and their birthday had passed, even though they had reported it to law enforcement, and the appropriate time was since they were past 25, they would no longer have to be compensated under this act. We believe whether you're 17, 19, 21, or 25, you should be able to be compensated under this act if you have experience with child sexual abuse. There still is the same party appropriate time for you're not changing that. And then the third change we're making, currently for claims to be made generally under the City Compensation Act, there is a 72-hour requirement. We're amending that to 140 hours. What I understand of 72 hours before we flow in the requirement, there's other states, it varies between states. Some states have as soon as practical. Some states have obviously an hour requirement. We are going to change that from 72 to 140 hours just to get the additional 2 days.
All right, Dave, any questions?
Thank you, Mr. Chairman. I want to make sure I understand the 25th birthday issue. Are you saying that if we remove that language, then a claim could be filed at any time after 36 months or within 36 months, even if the person has exceeded their 25th birthday?
So, we're saying that as far as this is specific child sexual abuse, we are removing this age barrier so that, if there was, that if a child was sexually abused, that they can still recover under this act even after.
Right, but I just want to make sure it has the effect you want it to have, because the way I read it is unless the claim, so we're not talking about prosecuting, we're talking about a financial payment from a compensation fund that's set up for these types of victims. Unless that claim is filed with the director within 36 months after the crime occurred. So if this crime occurred when someone was 14 or 15, are they only getting 36 months to report or make a claim?
They have that crime 36 months.
But I would caution you, because I like what you're trying to do, but line 14 says unless the claim has been filed with the director. That's not a criminal complaint. That's actually, we may want to see if that's not a 36-month hard cap and you remove 25 years old, which is great, but it may not accomplish the purpose that you meant to on that, just by the way I'm reading it.
The way I understand it is, you know, victims can follow the procedures, follow it within 36 months, but they can
Aged out. What you're saying.
follow that provision, but, you know, if they're after on their birthday, they were still able to be here, I'm not been told that there's any issue with 36.
Okay, because I mean, if you have 36 months to report and we were capping them at 25, you must have been 22 or less. I just want to make sure we're not frustrating the purpose.
Exactly. Senator Hickman.
I guess my question would then be on the same line that Senator Sparks. My understanding is that you have 36 months to file this claim after you're reporting to either one of these two agencies. But is there a time, I guess I think in our minds, we're putting in a time, is there a time limit after the abuse occurs until you report it to one of these agencies that's included in here? And then I'm guessing that's what they're saying, is that they could report later, and then from that time, they still have 36 months. Because I'm not getting how you get to past 25 if you're a minor, and then you only got 36.
That's fine. Thank you.
No, you're good. Thank you for being here. All right, did that get y'all's questions answered? Okay. You've heard the motion. All in favor of the motion, task force do pass. Say aye. Aye. Any opposed, nay? The ayes have it. All right, good job. Next bill is Senate Bill 2537, and we're going to recognize Vice Chairman Egan to present this bill.
Thank you, Mr. Chairman. This is a very simple bill, so I'll be really quick. There's an old law that we have that made it a felony to sell fireworks outside of season, I guess, or when allowable. This just takes it from a felony down to a misdemeanor, and that's all the bill does.
Okay. And I personally didn't even know there was such a thing in the statute as that, which I think is silly, but anyway, that's
Right.
what it does. And if you sell out of season, this would then go from being a felony, which is what it currently is, down to a misdemeanor. All
That's
right.
correct.
Any questions? All right. Not for motion.
I'll move title sufficient do pass.
Heard the motion, all in favor say aye. Aye. Any opposed, nay? The ayes have it. All right. Then let's go to stay with Senator England for a moment. Are you ready on the late on the table to call bill?
I sure am.
All right, let me call that bill off the table, Senate Bill 2073, and we'll recognize Senator England to explain what we're doing with that.
Thank you, Mr. Chairman. So this is the bill we discussed at length, I believe, yesterday morning, which involves fleeing or eluding a law enforcement officer. I have met with several of the members in here and have new language, which thanks to our buddy Ethan becoming a father for the third time today. He wasn't here, and I didn't have time to get with Karen to get a committee substitute, but she knows this amendment is coming in place that takes care of our questions we had the other day. So I'll just read these in here, and also let me go ahead and mention that there's going to be a reverse repealer at the end of this as well to help make sure that we've got this the way we need to have it. So that's coming as a part of this amendment as well. But Under subsection 5, what I've done is upon conviction, this will read, is subject to enhanced punishment of imprisonment in the county jail for a term not to exceed 1 year. So subsection 1 allows for imprisonment up to 6 months. This enhances that to allow not to exceed 1 year. So it doesn't get up to felony level, but it does add an additional 6 months. That is the enhancement. So that's over and on top of that. Then when you look at subsection 6, this amendment will read on line 48, it says shall be. After that, it will read shall be subject to an enhanced punishment of imprisonment or fine or both up to twice that listed in subsection 2 herein. So it is an enhancement. That makes it clear that it's an enhancement. Will allow if they violate subsection 2, and if you have one or more passengers, and I know I spoke with Senator Sparks on this, one or more passengers means it could have 4 or 5 minors. It's the same charge. So it's not a per minor, it's one or more. They will be, there's a possibility that they could then receive a fine not to exceed $10,000 and a not to exceed 10 years of imprisonment. So it is an enhancement, and it did take out the minimum, which was also a question in here. Finally, section 2 will just be amended to read our typical reverse repealer language to make sure that we've got this airtight the way we need it to, and to give us more time to visit on that, and maybe hopefully get us out of committee to discuss further.
Okay. And I want to thank you for working with Senator Sparks and Senator Simmons and Dickman and others on these questions, which I think were really insightful questions asked earlier. So any questions on, let's go ahead and offer your amendment. Why don't we do that? So you just articulated the amendment. Any questions on the amendment for Senator England? If not, all in favor of the amendment, say aye.
Aye.
Any opposed, nay. The ayes have it on the amendment. Now, any questions on the bill as amended? If not, for a motion, signature.
Title sufficient, do pass committee sub.
First motion, all in favor, say aye.
Aye.
Any opposed, nay. The ayes have it. All right, so we got a few more here. I think Senator England 2536, which is in your loose packet. It didn't make the original packet because I was slow in getting it to Mr. Alves, but it should be laying around on the table. If you don't have one, let us know. We'll get you a copy of that. All right, you're recognized.
Thank you, Mr. Chairman. So yeah, so again, we have there was a loose paper handed out, and then there was the committee substitute that Ethan got in. So Ms. Pat did get that to us. So it's proposed committee substitute for Senate Bill 2536. What this bill does is it creates a registry for offenders that have committed offenses involving public funds. So the registrable offenses are listed lines 27 through 32. Those involve embezzlement, defrauding government, and bribery here, bribery of an official. So it's involving public funds here in Mississippi. Anyone that is convicted of one of those offenses shall appear on this registry that will be held with the Department of Public Safety. That goes to them the same way in which if you're a sex offender, they keep that list as well. And if you're on this registry as an offender, you cannot hold a job with the state, county, or municipality, or any other political subdivision in a position of accounting, or in a treasury, or a registrar's office, or anywhere that monies are collected. So if you remember, I presented this bill for a couple of years now, but we've really narrowed it down here to deal just with public funds and to deal just with preventing people being able to hold jobs in offices that also deal with public funds. So the way I think of it is the same way that we have a sex offender list. We have that because people have proven themselves not to be trustworthy around our children. These folks that have committed these certain crimes have proven themselves not to be trustworthy with public monies. Now, that being said, whereas the sex offender list is a permanent registry, this is not permanent. This is 5 years from the date of conviction or the date that you finish up your term, whichever's later. And there's a provision in here that if you pay back all of your fines and retribution for the monies that were taken and serve your time, you can then petition the Department of Public Safety to be removed from the registry. So you don't even have to be on there for 5 years, but if you don't pay your stuff back, you're on there for at least 5 years, at which time you cannot be on any of those jobs. And just one more thing I did want to note, because this was something that came up in the past. This doesn't have social security number or anything like that on the registry that we'll have. That's lined out in one of our sections here. I had 41. Yes. So the list shall not include offender social security number, driver's license number, any other state or federal identification number, physical address, or phone number. So this is strictly narrowed down. I think we've got a very good bill here to get us to keep people from getting state jobs or municipal jobs whenever they've proven themselves not worthy of being around our public funds.
Are you done with your explanation?
I am, and I'm sorry. I do have one more thing, Mr. Chairman. So when we looked at this, if you look at Section 8, that talks about it says a person who is listed on the registry shall not be allowed to be appointed or hold to perform duties of any office of profit, trust, or honor. I felt that was a little vague, so I would like to offer an amendment to strike all of that in Section 8. It's not needed. It has current language in there, so the additions there are just going to be out. So after line 116, essentially this bill will end at this committee substitute with this amendment will end at line 115.
Heard the amendment. Any questions on just the amendment portion? If not, all in favor of the amendment, say aye.
Aye.
Any opposed, nay. The ayes have it. Now, questions on the bill. Senator Barnett.
Yes, thank you, Mr. Chairman. Senator England, did we pass this bill out of this committee last year?
We passed it out in 2020, and I know it seems like it was last year because the way our years have gone, but it wasn't this exact bill. That bill put more prohibitions on it. It was a longer term, and it added more offenses. So this narrows it down just to public funds offenses, embezzlement of public funds, bribery of a public official, and it also narrows down the jobs that they cannot receive under the state or a municipality or a county or any public entity. They can't work in an accounting office or a registrar's office or a treasury office.
Now, if my memory serves me correct, this bill, maybe not the bill, but I know there was some discussion at the time that the previous bill passed this chamber. Wasn't there some discussion as to where people who have been like principals at schools or something like this bill will also limit those people from becoming principals at other high schools? If it wasn't part of that bill, wasn't part of the reason why that happened before, as a result of that happening?
Yeah, so this has happened, yes. Well, and I don't know if it would actually, so this bill limits you from working in an office of treasury or accounting or registrar's office. But yes, that has happened where someone has stolen from a school board and moved across the state and gone, found themselves in a position where they're working right back at a school board.
Or in a principal's office administrative position too, correct?
If they deal with money and public funds, then yes.
But would you agree that if we're talking about the public side, then schools, and shouldn't they have the same opportunity to be warned if there was a bad actor from Jackson County School that's now applying for a job in Hines County? Shouldn't they have the opportunity to know that this was a bad actor there? And I'm just asking.
Yeah, so when you say bad actor, if it's one of the offenses that are listed in this bill, then yes, they would.
That's my next question. Would that be, so would a school, would a principal or a superintendent be covered under this bill, or would it have been taken out when you amended those lines from 115 to whatever it was that you just amended in your amendment?
Yes, it'll still be the law, because if you look above, so the Section 8, it has some previous law listed there. So I'm not cutting that out. I'm just cutting out what we added. So the part that references Section 8 is no longer needed.
But my question is, removal of everything in section A, would there still be language? Is it specified? Can you spell it out to me where these type of individuals will be included in this?
Well, and council, I believe, mentioned this previously. So that is currently in law, and we're not removing that from law. But those folks, I'm sorry, I'm just not changing anything to do with that. So those are still.
Okay, I'm just asking though, I mean, where is it that the people that I'm talking about is included in this? I just don't, if we're gonna talk about it,
Right.
then we're talking about public funds.
Right.
And we shouldn't think that public funds are just those public funds that somebody embezzled from the courthouse or from the mayor's office.
That's
Because
right.
we do have public funds that support our public schools, and I think that every public dollar in our public schools should be held accountable, and the people that are in charge of those public monies at our public schools should be held accountable, and we should not give them a pass to be able to travel from school system to school system and not be part of some type of registry. Well, that's why.
So I think that. That's right. So that is actually captured in here. And if you look at, so there's.
Language in
That's right. And sections 97-1125 through 97-1131 already deals with embezzlement by a public official, which would include that. So they would be on the registry for having done that. Same thing with defrauding of state and local governments, which is section 97-710. If they do that, they go on this list.
Let me ask you this question.
Yes.
I just want to ask this question as well. If somebody is convicted of a sex crime and they're only given probation instead of a prison sentence, they're still a sex offender and have to register, right?
Mhm.
So if somebody is convicted of this and given probation and not a jail sentence, are they still on this registry?
Yes, they are. Yes. Yes, probation or sentence. That's correct. And again, another thing that I wanted to do by adding that you can petition to come off the list if you pay your retribution, you pay your fines and everything. I want that should be encouraged because we see that too often, that people don't get, they get hit with these they get convicted of these crimes. They owe the state or their city or whoever the money back, and they're not paying it. So I want them to be encouraged to go do that whenever they've done that. And this allows them to petition to be removed from the registry once they've done that and once they've served their time.
Okay, once they do this, if they decide to do this and they decide to pay their fine, are they removed from this registry 5 years after that, or just immediately after that? And the reason why I'm asking that, if I was on this registry and I'm at year number 4.5, and I decide that I'm going to now pay everything that I owe, do I come off in 6 months, or do I have to wait 5 years from the time that I've settled my debt, like we do with people incarcerated with the Department of Corrections? Some of them they don't get any relief even after they've settled their debt. So my question is, do they get relief after they pay it, or do they get relief after 5 years, regardless of when they pay it?
Yeah, the 5 years is regardless. The 5 years after conviction or after their time is served is regardless. They were moved from there after the 5 years.
Would you be open to another amendment then, Senator?
I don't think so on that. But I would like to talk with you more about it. But again, when dealing with this bill, and of course, this is not currently in statutes. This is something we can come back and revisit again as well if we find out that it's not working the way that it's intended to.
The reason I'm not going to offer the amendment because you're not feeling it, but my reason for wanting to offer it is the fact that what if somebody owes a substantial amount of money, don't pay it back, but they still get to come off the list in 5 years? How did we do our school system or whoever they took the money from? I mean, so basically we just said, okay, we're going to give you the right to steal and not have to pay it back as long as you don't steal again in 5 years.
Right. Well, that's currently happening, but this at least gives that that one extra bit that, look, you're on this registry for this period of time.
So if I stole $1 million and I'm on this register for 5 years, I could care less what happens to me after 5 years. I mean, to me, nothing happened. All I did was just, all I am is on a register. I think there should be some type of penalty other than being on the register and come off after 5 years. But we'll
Okay, I
say that
understand.
for a later day.
I understand.
Senator Hill has to be recognized first, so we'll recognize her.
I understand exactly what Senator Barnett's saying, and just keep in mind, the thought is, if you're gonna punish somebody, like he said, if they steal $1 million of public funds, in 5 years, they're scot-free, they don't have any, they're not on this list anymore. I mean, they might still find it in their background, but I think what Senator Barnett is saying is, unless and until they pay it back, they stay on this list. That's kind of what I'm thinking. But what you got is a good start.
Senator Simmons.
Thanks.
We
Yep.
recognize you.
Thank you, Mr. Chairman, and thank Senator Barnett and Senator Hill for your concern about it. But registration, whether it's sex registration and the actual what the sentence is, they are two different things. So this is not doing anything different with the registration that Senator England is talking about, and the actual sentence itself by the sentencing judge is something totally separate. So if a person was sentenced and that sentencing judge said you have to pay $1 million in restitution, and that person fails to do that, then they still can be brought back in front of that sentencing judge, be made to go to a restitution center, made to actually, if they violate another crime, they can actually be revoked to go to actually prison for committing another crime or any other term or condition that's in the sentencing order that they violate. It's handled at that circuit court level. The registration that Senator England is talking about is just something totally different. Okay.
Any other questions? If not, Senator, for a motion.
Okay, I believe I'm going to do this correctly. I'm going to move for title sufficient due pass committee sub as amended.
That looks fine.
All right.
All in favor, say aye.
Aye.
Any opposed, nay? The ayes have it. All right, Senator England, I think there was another bill, right, that didn't make the list that you were working on. 2543.
That's right.
Yes, we're gonna recognize you for Senate Bill 2543. Again, it's in a loose packet here. You're recognized.
Okay, guys, and this is a long one, but I'm going to try to get us through here as quick as we can. I think I can do that because I've got a good outline here that we have. This comes at the request of our Department of Public Safety. A lot of it is to clear up some language, but while we've got it open, we're doing some other things here. So let me run through this the best I can. In section 1, if you look at lines 45 to 47, that's just gonna clean up the language that has been there. You see they add forensic laboratories. That's just to make sure that those are named the same as they should be throughout. And then it also adds under subsection J and K, the Office of Driver Service Bureau, which was previously the Mississippi Highway Patrol. Mississippi Highway Patrol was removed from Driver Service Bureau. And then you have the Commercial Transportation Enforcement Division, CTED, was transferred, I believe, by bill last year from MDOT to DPS. And so that puts that in there under its own subsection there under section 1. If you move over to section 2, when the Bureau of Mississippi Bureau of Narcotics was moved over to DPS, there was some language that was under a different statute that transferred over. So this now, well, number one, under 152 and 154, you'll see it changes employee to agent. That's to keep us with language that's contiguous throughout, with that's similar. Then if you look at lines 164, this gives the same job protection to other employees. It gives MBN employees the same job protection as Mississippi Highway Patrol, and just cleans up that language to make that the same standard throughout, since that was moved over. On section 3, what this does is it allows the Commissioner of Public Safety to have any medical examiners that are called to testify. So if they're subpoenaed, a lot of times what's happened, they're subpoenaed and it's not even going to be contested. This will allow the department to request expert witness fees to be set by the director. And then this language does require that the fee be a reasonable fee. And kind of on those same lines, moving over to section 4, when there is a medical examiner needed and it's not going to be a contested issue, or there's not going to be challenged by an opposing witness, that will allow these crime lab employees and medical examiners to appear. They can appear by not telephonically, but remotely appear. So that will also save on expenses and also allow for them to do that much easier, because we know our crime lab and our medical examiners are always in a tight spot, and that can hopefully help that move a little better. If it's challenged testimony, then it's not going to be. You can't do that. You can't appear remotely if it's going to be challenged testimony. Section 5 will allow. Let me catch up with my own self here. I'm trying to move as quickly, noting the time here. What Section 5 will do, if you look at Section 410 to 414, it allows the Department of Public Safety to have salary setting authority and authority to set minimum qualifications for the employees at the Mississippi Forensics Laboratory and the Office of State Medical Examiner. These are people with very specific skill sets that the Department of Public Safety relies on these folks. And again, we want to keep our people in our crime lab, want to keep our medical examiners there. This allows the commissioner more authority to keep those folks there and to set salary and to set requirements. Section 6 and Section 7 are very similar, so I'll try to address both of those at the same time, because one deals with firefighters and first responders, law enforcement officers, firefighters. Section 7 deals with, local emergency management, So what this allows is for the commissioner to receive funds if we have another event like COVID, they want to pay death benefits, and it also allows the commissioner to explore the option of obtaining a life insurance policy for individuals. I believe there was a cheaper option where they could pay $100,000, I believe, in life insurance benefits out. When I talked to the commissioner, I felt like that was also another way for us to attract new officers to come in. So even if they're off duty, they'll have this life insurance policy to cover them. For instance, in DeSoto County, the officer that was at the beach and went out to save some children that were drowning, and he was off duty. He was able to save the children, but he lost his life in the process. If the commissioner were able to find life insurance to fit that, then that gentleman would have had that life insurance policy. Wasn't a line of duty death, which is in place now. So again, it's an extra incentive that will allow them to do that. That language is there for that purpose. Section 8, this is just a very old law that while we've got this code open, we're looking at that to remove that. It requires convicted felons to register with the chief of the police or the sheriff in the jurisdiction with which they reside. That doesn't happen now. This does not affect the sex offender registration or anything that's outlined in other codes like that. And with that, I will be glad to have any questions. I know we have some of our partners over here from the Department of Public Safety that can maybe help me answer some questions if we get to them. And but that's
sounds sufficient.
Let's see any questions for Senator Sparks.
I'm sorry, Mr. Chairman. Yeah. Yeah, me too. But we're about to end up in the appellate court. On line 335, I understand the intent, but I got to look at the language on that. It's a confrontation clause issue. With 335 in a criminal trial. Well, I'm looking at the strikeout version. I'm sorry, it's subsection 4. In a criminal trial, so you're telling me we're having a trial and there's testimony, and it's it's unchallenged, you mean by another expert? It's not contested by another expert?
Well, it says unchallenged, 337 says unchallenged by an opposing witness, so it doesn't.
Okay. But
necessarily
if
indicate-
I, as a defendant, want my attorney to cross-examine, we got a problem, don't we? That's confrontation clause 101.
Well, and look, so the issue there, and I understand your concern, I think it's a concern that we need to look at, but the issue is that these medical examiners are being subpoenaed.
Understand that, but that's the process. If I stipulate to this as an attorney, I probably get recommended to review by the bar. I really think it's that bad, guys. That's just my.
My question, are you talking about what you're proposing here? Are you proposing they don't show up in person? That they show up like on a Zoom type thing where they can still be cross-examined and just not be physically present in the courtroom itself? Or are you simply saying they're submitting just their opinion like in a paper form?
Oh, no, that will allow them, when unchallenged, so you can still, you appear remotely, so you're online or you're via Zoom, so you're still appearing in court and you're still available for cross-examination. I'm sorry, I thought your question was dealing with another section when I answered.
You're still on point, because the way I read it, unchallenged by an opposing witness means I bring an expert to refute your expert. So if I bring an expert to refute your expert, you have to show up in person. I get that part. The problem is I know of no circumstance in the state of Mississippi where you can testify remotely and it satisfies the confrontation clause. I'm asking legal. That's kind of my question. I don't understand the reason, but I'm afraid you're setting yourself up for appellate issues.
Okay.
Would be my question, I guess, if we consider that.
Okay. Well, yeah, and look, I think that's a great question. I think that that we can look at that. I'm not aware, and I guess we can ask counsel maybe if that's something that you're aware of.
Senator Sparks, if you would like to offer an amendment at this time, and then if we find out later on that your concerns were not valid, I'm sure you would maybe entertain the motion to put it back the way it was. But if you would like to offer an amendment, we'll certainly recognize you for that amendment.
Thank you, Mr. Chairman. I'll be honest, I would probably offer a reverse repealer at this time. That way we've got time to work on it. I don't want to hold it up. There's a lot of good stuff that's happening. Then one last question. I couldn't find it as you were talking. But did you say that we were going to allow sex offenders to register at the county sheriffs? That was not said.
No. So what that section does is requires all felons. Right. Okay. Well, look, so if
I misunderstood you.
So if we take a vote on I understand the amendment, and I think it's a friendly amendment to allow us to work on things, so we'll do that.
I would just offer a reverse repealer at the proper time.
This is fine, let's do it now. If you heard the amendment, all in favor say aye.
Aye.
Any opposed, nay? Yeah, that was great. Did you finish your explanation?
I did, yes, so explain the bill.
I have one very quick question. With this fund that we set up, for either, like, they would just pay them the $100,000, or they have the option to set up, insurance fund. My question is, are they gonna take one route? Like, do they plan to take one route, look it up and say, we're gonna have a fund for this, or we're gonna take the route to get insurance policies on it?
Yeah, so it just allows the commissioner to look into it. So it doesn't require him to do one or the other, but from after talking with the commissioner, I understand there's some of these instances where he could get $100,000 policies on these individuals for a very low amount, which would again allow the family to have access to the $100,000 even if the officer is not in the line of duty. So the way I look at it is we want individuals like this brave individual from DeSoto County that went out into the water to save the children during the riptide. He was away from his home, but he still acted because he was a rescue swimmer. He went out and got him and brought him in. So this would allow him to have had the $100,000 life insurance.
Yeah, I totally get that part. I just, my question is, at some point, do we come back and say, everybody out of the fund that didn't mind it, or everybody gets insurance policy? I like the insurance policy I did. That's why I was wondering why we just didn't go toward one way or the other.
Right. So I think the option that we just allow it to occur. So if, who knows where the insurance policies are going to go and where the amounts of policies are going to go. allowing the commissioner the authority to do that while policies are cheaper. Because if it becomes too expensive, we require it one way or the other, we could end up in a situation where we maybe can't even fund that. But if it works out great, then I think that it'd be something we could come back and look into, because it's not even allowed to happen at this point in time. So it might end up being a better situation, but I appreciate the question, Senator. That's right. I'm probably talking too fast. I meant premium, not, so you obtain the $100,000 life insurance policy for a premium that is not very expensive. It's something that the DPS, not a cheaper policy. It's it allows the commissioner to look at premiums and explore that option.
Because the current law, as I understand it, and y'all can correct me if I'm wrong back there, there's this fund set up for when officers die in the line of duty, then they can access $100,000 per fallen officer. And there tend to be around 10 to 11, 12 of those sometimes a year. So that's the amount of money we're currently dealing with. I think what Commissioner Tinzel is willing to explore is that instead of just holding this money, $1 million or whatever, for those instances, could we take a similar amount of money and cover all the law enforcement with insurance policy, so that if they pass away either in the line or out of the line of duty, they're still going to have the $100,000 of their family as well, versus just hoping that no more than that many people die and we can afford to pay that out each year. So I think that's the gist of what we're talking about. No, it would be in the name of those officers.
The beneficiaries would be the families, right?
Senator Hill, you got it. Okay. I'm sorry. I thought I saw your hand go up. All right. Did we answer your questions? All right. Any other questions? We have the amendment in place, so there's a rush filler. Any other questions? All right. For a motion?
You made it. I liked it when you made it earlier. Title sufficient, due pass committee sub.
So all in favor say aye.
Aye.
Any opposed, nay? The ayes have it. All right. One last bill, if I'm reading my agenda correctly here. And this is one that came to us from corrections. So for those of you who are on corrections, maybe several of you you've already heard this. That's 2584. This is the Reentry Court Act of 2022. And basically, I'll try to be extremely brief because I know the hour is late. This is essentially a drug court set up for non-drug offenses, is my understanding. So many of you have heard Judge Harold, that circuit judge down from my area, that's been a fairly big proponent of that, in Senator Hill's area as well. He runs the drug court. So what this bill would allow is a senior circuit judge in any district in the state, if they choose to, can set up this reentry court for non-drug offenses. Of course, I think it's related to no new money is required for this for the state. Section 4, time spent in the program doesn't count for parole purposes. So if you get in the program and then you mess up, then you're back to being sentenced by the circuit judge, just like you are in the drug court. The eligibility is in Section 5. In Section 6, the defendant is eligible to be sentenced to this program if all the following criteria are met. The defendant has been previously convicted of one or more felony offenses in the state or any other state or federal court. The defendant meets eligibility and suitability standards for sentencing in the program established under Section 3. The court determines in the best interest of the community as well as the interest of justice for the defendant to be sentenced into this program. The defendant's suspended sentence for the charge before the court shall not exceed a term of incarceration of 20 years. So for the very violent offenses, obviously the terms could exceed 20 years and they're not eligible for this particular reentry program. The defendant shall not have any prior felony convictions for any offense that's defined as a sex offense or any other substantially similar offense in another state or substantially similar federal offense. The crime before the court shall not be a crime of violence as listed in Section 9732, except house burglary under Section 97-1723-1, which is of an unoccupied dwelling. The defendant cannot be sentenced in the present charge as a habitual offender. And other criminal proceedings alleging commission of a crime of violence is listed in 9732, except house burglary again of an unoccupied dwelling shall not be pending against that defendant. crime before the court shall not be a charge of any crime that results in the death of any person. So these are all the criteria that you have to meet in order to be eligible to even be considered. And again, it's not a requirement. If the judge views the nature of the offense, the crime charge, any special circumstances, they can take into consideration. Also, the probability of whether the defendant will cooperate and benefit from said program, whether the program is appropriate to meet the needs of the defendant, the impact of the defendant's sentencing upon the community, of course, in conjunction with the district attorney and the involved law enforcement agency, and recommendations, if any, from the victim. There's a lot of boxes they have to check in order for this person to be entered into the program. If the reentry court determines that the defendant is not eligible, then of course, they will typically state the reasons they believe that that's the case, and there's just not admitted into the program. If the defendant is eligible for sentencing this program and the reentry court has confirmed that there is adequate bed space available, so in some instances, they may meet all the criteria, but then the circuit judge may contact the facility that they would like to put them into, and if there's not space available, then obviously you can't put them into a program if there's no space available. All right. Before the sentencing of the program, the defendant shall waive the right to trial, enter a plea of guilty to the charge, and be sentenced for the offense. And then it's held in suspension pending the outcome of whether they make it through the program or not. Yes. Okay. Wait a minute. I'm trying to be thorough here. Senator Hill, for a question.
I'm trying to think of the list of the crimes that are not in 9732. So carjacking and potentially drive-by shootings. Trying to think of some of those. Of course, all the white collar crimes.
It cannot be a crime of violence.
Right, but I'm saying all these crimes are not crimes of violence. So would DUI be fair game in here?
I think so.
And like carjacking, that's not a crime of
No,
violence.
that's a crime of violence.
Is that a crime of violence? Okay.
Yeah, yeah.
Is that a crime of violence? But like the white collar crimes. So we're allowing burglary of a dwelling.
Unoccupied dwelling.
Unoccupied dwelling, okay.
Senator Sparks.
Yeah, just briefly to that, because I think we talked about this last time it came through. Several years ago, we had the RID program, and we were able to do a non-adjudication, and we did a lot of burglary and unoccupied dwelling at the discretion of the judge, the DA, et cetera. The big thing about this, I think that people forget with reentry court, and there's a piece, and I want to work with you, Mr. Chairman, to work on this. I kind of regret that this is somebody who's already had a felony. I think you could get a situation where somebody doesn't have a conviction, but has gotten 5 or 6 felonies, with a drug problem, et cetera, and they would qualify, but we couldn't let them into reentry court. That's something I would like to discuss with you.
Sure, do they not qualify for the drug court?
Well, potentially, but sometimes they don't offer that, because if it was a burglary dwelling, they wouldn't qualify for drug court. But the reason I say that is this: when somebody enters into reentry court, because I want to make sure this is clear, they give up their right to ERS. There's no good time. There is no benefit. They do not count toward the probation percentages as long as they're in that first 36 or less months. So if you go in and you do 24 months and you don't perform, and the judge says, I'm just going to sentence you back, you don't get credit for any of that. So it's actually a sentencing bill. It's a stricter bill. You're going to have more time than you would in a normal situation. So I certainly don't want people to think this is like a non-adjudicated plea. Somebody's fixing to go to prison for as long as the minimum time that MDOC says the program lasts, and they're not going to get 1 day credit while they're in there. I just wanted to kind of make that point.
Yeah, appreciate it. All right, any other questions? Senator Burnett.
Yes, I just wanted to say 2 things. Y'all ready to go? But the 2 things is that, last year when we passed this bill out of committee, it was only 3 or 4 districts that was involved. This year we've expanded it to any district that would like to do this, because we understand that we can't save a piece of the state without being concerned about the whole of the state. So this is the reason why we're doing this, to allow every circuit that wants to do this, to do this. And the other thing is, it's not costing Mississippi any money. There's no new money to do this. So this is purely, something that if that judge that wants to do it can do it, but there's no money to encourage anybody to do it. So just want to let y'all know that. And I have a motion in the room.
All right, you recognize the motion.
Title sufficient do pass as amended.
All right, you've heard the motion. All in favor say aye. Aye. Any opposed, nay? Ayes have it. Rise and report. Thank you. Thanks for your patience. Thank you.